Hello there. This is Professor Nathenson. This is another video, another discovery video. This is video number 5 in the series of discovery videos. The topic of this video is about mandatory disclosures under Rule 26A and a party's duty to supplement discovery and disclosures under 26E. Let's start off with disclosures. And as we typically do, I'm going to start off with the questions, the study questions themselves, and I'll jump back in and forth between the questions, the rules, some hypos, and things like that. Okay, first question. What's the difference between disclosures and discovery? Compare Rule 26A1 with 26B1. Well, we'll recall that Rule 26B deals with the scope of not disclosures but of discovery, and we talked about that in another video. Discovery of any non-privileged matter that's relevant to any party's claim or defense and is proportional, so on and so forth. Go back and watch the other video for information on that. And as we're going to see very shortly is that discovery includes things that you ask for. That could be a deposition. It could be interrogatories, it could be requests for admission, it could be document requests, it could be medical exams, and so on and so forth. Discovery is stuff that you ask for. Disclosures, in contrast, are not things that you ask for, but rather things that must be given to you without you having to ask for them. Put differently, disclosures are things that a party must provide to other parties automatically without being asked. Okay, it's not a may, it's a must. Okay, so that's the difference between disclosures and discovery. Now, if we take a look down here, we'll see there's 3 kinds of disclosures. Let me get a highlighter here. There's 3 types of disclosures that need to be met under Rule 26A, required disclosures. There's initial disclosures. Those are done quite early in the litigation. There's expert testimony disclosures. That's done somewhat later. And then there's pretrial disclosures. Now, I'm going to talk, for the most part, about initial disclosures. Okay, we're going to focus on that. And what we're going to find out is initial disclosures are again done very quickly, and they're going to be information on individuals with discoverable information, information about documents, ESI, electronically stored information, and tangible things, all right, computation of damages, and copies of any relevant insurance agreements, okay. Now, something interesting about initial disclosures is that they're pretty narrow these days. They used to be, in 1993, disclosure of those categories of information that is relevant to disputed facts alleged with particularity in the pleadings. Okay, that could be any facts, whether they're claims, defenses, so on, you know. Denials of an alleged fact, as long as it was alleged with particularity, there would have to be disclosure on that material. Well, a lot of lawyers objected to that because that would require lawyers to disclose information that would hurt their clients. So back in 1993, this version of the disclosure rule, 26A1, local district courts were allowed to opt out of that, and a number of them did. But in 2000, the rule became mandatory for all district courts, but the scope of initial disclosures was narrowed. So now it's not just any facts that are disputed, you know, for claims, defenses, or whatever, but instead parties have to disclose certain information that the disclosing party may use to support their claims or defenses. Okay, so in other words, anything falling within those categories of information that you could use to help you, right? So you wouldn't have to disclose information that would hurt you. You'd have to disclose certain sets of information that would help you. Now, that doesn't mean that you can hide information that hurts you. Rather, what it means is that information that falls within these categories, okay, names of witnesses and parties with information, documents and the like, damages, and insurance agreements, you'd have to give up, and here, of course, we're talking about 1 and 2, documents and witnesses, okay? You don't have to give up the information that's going to hurt you. You have to give up the information that's going to help you, and you have to do that as a matter of automatically without being asked. Now, what about information that hurts you? Can you just sit on that? Can you hide it? And the answer is no. You don't have to disclose it under Rule 26A1. No disclosure requirement, but information is still discoverable, right? So if somebody asks you for that information, you still would have to give that information up so long as it falls within the Rule 26B1 scope of discovery, which looks to non-privileged information that is relevant to any claim or defense, right? So you don't get to hide information that hurts you. You still have to give it up so long as you're properly asked for it within the scope of discovery. Now, that's not what we're talking about. Now we're talking about the initial disclosures, right? So we've talked a little bit about what the differences are between disclosures and discovery. So I'll consider this addressed. We've peeked ahead at the categories of information that are initially disclosable, right? We've looked a little bit about the difference between 1993 and 2000. Let's very briefly note types of suits where disclosure is not required, right? They're exempt from an initial disclosure. And we're going to see that most of those involve some sort of governmental litigation, right? An action for review on administrative records. Say something's gone, for example, from the federal agency up to a district court, right? Or it's on a petition of review from an agency. All right. So there's no disclosure requirement. A forfeiture action in rem, that property, of course, arising from a federal statute. Okay, that's probably going to be the United States trying to grab your property for some violation of the law, right? For example, maybe a house was used as a drug house, right? Habeas corpus, or other proceeding to challenge a criminal conviction or sentence. Okay, that's going to involve somebody trying to free or to get a new trial of a prisoner who's being held in another state or federal custody, right? An action brought without an attorney by a person in custody of the U.S., state, or subdivision. Same idea, essentially, as number 3. To quash an administrative summons or subpoena, again, dealing with the government. Action by the United States to cover benefit, government. U.S. to cover student loans, government. Arbitration award. All right, there's already been a proceeding, right? An arbitration proceeding, and now somebody's trying to enforce it. And I skipped over this one. Proceeding ancillary to a proceeding in another court, so we have another litigation. We don't want to complicated things. All right, if we look at these ones here are all dealing with government, particularly with federal government or federal government litigation. So, probably the reason this rule exists to exempt the initial disclosure requirement is to avoid putting additional burdens on the government because the taxpayers pay for all of that. But in other kinds of actions, say copyright lawsuit, right? Diversity action for negligence or for breach of a contract, a federal question suit for, say, federal employment discrimination. Well, typically those are all going to not be exempt, and therefore these initial disclosures are going to have to be provided. All right. Now, I think the answer to number 3 should be pretty obvious, right? If a party does not request initial disclosures, must the opposing party provide disclosures? All right, let's look under the relevant section of 26A1. There's actually A1E. Is it A1E? Let's say A1. Let's see, A1. Yeah, I was right. A1E. Okay, under A1E, a party must make their initial disclosures based on the information then reasonably available to it. And in a little bit, we'll talk about the duty of supplementation, right? What if, you've gotten something wrong and you later find that your disclosure is wrong, do you have to supplement? And we'll talk about that in a bit. This is important. A party is not excused for making its disclosures because it is not fully investigated, or because it challenges the sufficiencies of another party's disclosures, or, especially this last clause, because another party has not made its disclosures. In other words, even if the other party refuses to make disclosures, you still have to make your disclosures. Okay? Okay, you have to do that. You must do that. Now, what about the timing for initial disclosures? You got to make your initial disclosures within 14 days after the 26F conference, unless a different time is set by stipulation or court order. And if you go back to the video we did on Rule 26F, the 26F conference, that's the conference that has to take place within 21 days before the scheduling order is going to be done by the court. And then 14 days after the 26F conference, the parties have to submit a proposed discovery plan to the court, right? So, normally you're going to have to make your initial disclosures 14 days after your 26F discovery conference, unless, and there's a variety of circumstances here that varies from that, unless you set a different time, the parties agree, stipulation or the court order, or unless there's a party objects during the conference that disclosures are inappropriate, states the objection in the discovery plan, right? And then later on, the court will have to determine the disclosures that need to be made and the time for disclosure, right? Okay, so again, our basic rule is you got your 26F conference, and then plus 14 days after that, you got to do what? The initial disclosures have to be made under Rule 26A1. And you'll also recall that under Rule 26F, the proposed discovery plan to the court, and that's under Rule 26F. Okay, and then plus another 7 days is typically when the court is going to issue its scheduling order under Rule 16A. All right, let's go up here, see what else we need to discuss next. What must be disclosed initially? See 26A1. We already did number 5, when must disclosures be made. All right, we already did that. What must be disclosed initially? Let's go in a little bit more detail about what has to be disclosed. Okay, first, witnesses and people with information, right? The name, and if known, the address and phone number of each individual likely to have discoverable information. Not that does, but is likely to have that information, along with the subjects of that information that the party may use to support its claims or defenses, unless that use will be solely for impeachment. Okay, we'll get back to this language a little bit. All right, just keep in mind that this first category is about individuals likely to have discoverable information. Second is copies of all documents, ESI. All right, that's electronic information like computer files, stuff on phones, electronic information, say like IP addresses of people visiting websites, things like that. Intangible things the disclosing party has in its possession, custody, or control. And then there's that same caveat, right? Or that same condition. May use to support its claim or defenses. We'll get back to that later. So here, you need to have stuff, right? Documents, ESI, tangible things, okay? So you either have to give copies of this stuff, or you can just describe it. Description by category and location. I suspect that in most cases, what's actually provided in initial disclosures is not the copies just yet, but a description by category and location of the documents, right? So instead of giving, 20 boxes worth of documents, the initial disclosure is more likely to just say what they have and where it is, right? Category and location. All right. We'll get back to number sub 1 and sub 2, particularly this last clauses here, okay? Because it's important to read these carefully, and we have some hypos to test it. I'll briefly talk about these last two categories. Computation of each category of damages claimed by the disclosing party. So that's either going to be, okay, we're talking damages here, right? It's going to either be by a plaintiff or by a defendant who has a claim, right? Defendant with a counterclaim or with a cross claim, right? Or with a third party claim. In other words, claimants. And they also have to make available for either inspection and copying under Rule 34. Okay, that's the production rule. The documents or material unless privileged or work product. Now, we've talked about privilege. We talked about work product in a separate video. You can go back to that video. And it goes on and on. I'll let you read the rest for yourself. Now, that's about damages. We'll talk about the purposes of these in a minute. The last is for inspection and copying under Rule 34, any insurance agreement under which an insurance business may be liable to satisfy all or part of a possible judgment in the action or to indemnify or reimburse. Okay. Insurance. And let's talk about why each of these things are required. As always, if you think about why the law is the way it is, it makes it much easier to understand what the law itself is. Well, giving up contact information and names of witnesses and individuals likely to have discoverable information, that makes it easy for your opponent to start talking to or doing depositions of, more likely, right? And doing investigation into the people that are going to support your case, right? It makes sense that you ought to give that information up. After all, you're planning on doing it. Despite what people think about, the law, a trial, on the rare occasions when one happens, a trial is not something that involves a lot of surprises. They're rather highly, I would say, scripted, but people know pretty much everything everybody's going to say and everything's going to do. There's typically not really supposed to be surprises at a trial. So, if you're going to assert a claim or assert a defense, then the rule expects you to pony up information that you're going to use to support yourself. And here that would be witnesses and the identity of other persons likely to have discoverable information. The second category, of course, is the same thing, but it's stuff rather than people, right? It's documents, electronic information, and things that you're going to use to support your claim or your defense. That makes sense as well. The damages is so that your opponent can estimate the value of the case, right? And we combine that with number 4, insurance information. Well, let's be honest. Once your opponent knows how big your insurance policy is, that kind of gives an idea on the settlement value of a case, right? So suppose you sue, Bob for an auto accident, okay? And, your investigation suggests that Bob just really doesn't have any resources, but he has an insurance policy that has a cap of $300,000, per incident. Well, you've then probably found the upper value of the case, right? $300,000. Maybe Bob doesn't want you to know that, but the rule makers have made the policy determination that this kind of stuff, this kind of information needs to be ponied up and given quite early, likely with the goal of spurring settlement, right? So once you know what your opponent has in support of their case, that's categories number 1 and 2. What their likely damages are if your opponent's a claimant, right? Category 3. And how much insurance is at hand, category 4. Now, you're much likelier to be in a position to really sit down and make an early determination of the value of the case. And then you can sit down and think about how much it's going to cost you to prosecute or defend, how much the case is worth or is likely to be determined at trial to be worth, if anything, and maybe you settle. So, that's one major purpose of the initial disclosures here, which is to spur settlement, right? And I think another one is to allow you then to take that information and tie it together with the information you've gleaned from the Rule 26F conference, again with an eye towards making realistic judgments about the strength of your case and the strength of your opponent's case, again with an eye towards settlement. And it's really important for us to take a moment to breathe this in and think about it. Because as I noted in class the other day, one of the outcomes I have in mind for you is an appreciation for procedural justice, right? The values and social values that underscore procedure, which then help to explain why the rule makers decide the rules can be one way versus another. And it seems like what I've just showed you is gleaned very much towards a realistic appraisal of the strength of a case with an eye towards settlement. Note how that elevates settlement and conflict resolution over, say, necessarily justice, right? Or over truth seeking. Now, I don't mean to sound like that's a criticism, but rather to make us appreciate how rule makers can elevate one procedural value over another, and maybe elevate one and frustrate another. Whether you think that's a good or bad thing, I'll leave to you, but I do expect you to be thinking about those things. All right, so we've gone through questions through 5. All right, question number 6 is going to get us right into this language about what supports a case, what doesn't support a case, and so on. So I'm actually going to ignore this question. I have a better hypo down below. 2 witnesses, one who supports the defendant's defense, and the other one that will support the plaintiff's case. Which must be disclosed and why? Well, the quick and easy answer is you only have to disclose the one that will support your own case. The defendant has to disclose the witness who will support the defendant's defense and not the one who will support the plaintiff's case. But let's come up with some more interesting and difficult versions of these hypos. All right, so P sues D, alleging that D was driving drunk, right? So let's draw this. P versus D, negligence based on drunk. All right, D's answer, D1, not drunk. So that's a denial, right? Asserts the affirmative defense that P is comparatively negligent, so that's an affirmative defense. All right, there's 3 witnesses, W1, W2, and W3. Which ones must D disclose? So again, P versus D, alleging D is negligent as drunk. D's answer says, 1, I deny that I was drunk, and 2, the affirmative defense that plaintiff was CN, contributorily negligent. All right, who must D disclose? Witness 1 would testify that D ran into P's car. All right, is that somebody who supports D's defense, right? No, it's somebody who helps P's case, right? So it would appear that this is not not a witness that D needs to disclose because it doesn't support D's case. And indeed, we go down to the rule. Let's clean this up a little bit. This is obviously a category A1, right? Name and other information of each individual likely to have discoverable information. All right, well, witness 1 has discoverable information, all right, that the disclosing party, now here that's going to be D, right, may use to support its claims or defenses. Well, D is asserting a denial and an affirmative defense. So D doesn't have any claims. D does have the defense, right? For example, affirmative defense of contributory negligence. Does this witness have information that supports the affirmative defense of contributory negligence? The answer is no. Witness 1 has information that hurts D's defense and in fact helps P's case. So witness 1 needs not be used. Now, I know what you're thinking. What about this? Unless the use would be solely for impeachment. So let me note that briefly and we'll get it out of the way. All right. Impeachment is not like when you kick the president out of his or her job, okay? Or you fire an associate or Chief Justice of the Supreme Court. It's not what impeachment means. And here impeachment means putting on evidence that paints somebody as being a liar, right? Impeachment means you put on evidence that calls into question someone else's capacity for being truthful, right? So impeachment evidence would be something, for example, that might show that the plaintiff was a liar, right? Or some witness was a liar. All right, so the way the rule works is normally you have to disclose individuals with discoverable information, so long as that information is used to support the disclosing party's claims or defenses, right? Unless the only purpose of that use, the only good reason that the disclosing party, here D would use that, would be to paint someone else as a liar. Okay, now you'll learn more about impeachment when you take evidence, but I think you have a pretty good idea, right, of the type of evidence that might be used to paint somebody as a liar, right? Some sort of evidence saying that this other person has lied before and then they're not truthful and so on and so forth. All right, well, in this hypo, there's nothing to suggest that witness one's purpose would be for purposes of impeachment. Rather, the only thing that witness one could say is that D was, D was drunk, right? That's what it says. Yeah, no, D ran into P's car, that's right. That doesn't support the defendant. That helps the plaintiff's case, and it's not impeachment evidence. Therefore, since the information helps P's case, no disclosure of witness one. How about witness number 2? Witness 2 would testify the defendant was driving drunk and the plaintiff was texting while driving. Well, now that's interesting. Driving drunk, that hurts P. Excuse me, that hurts D and helps P, right? Well, since the rule says you only got to disclose witnesses or people that support your claim or defenses, reason number 1 doesn't support the defendant. But reason number 2 does support the defendant. That helps D because D is saying P was contributorily negligent, right? And it hurts P, right? So this information supports the defendant, and that information is not used just to call somebody a liar. In fact, there's nothing in this testimony that suggests that it's for purpose of impeachment. So what we have here with witness 2 is a dual purpose witness. Some of the testimony will not support the defendant and some of it will support the defendant. Well, if the defendant wants to use witness 2, then we're going to have to disclose this witness, okay? We're going to have to disclose this witness. All right. What about witness number 3? Witness number 3 would testify that D was not driving drunk. Well, this is interesting. Is this an affirmative defense? Well, let's start it this way. All right. Does this help P or help D? Obviously, this helps, in other words, supports D's case. But not so quick, you might think. This might support defendant's case, but the rule doesn't talk about revealing people to support your case. It says support your claims or defenses. Well, D has no claims, but D does have a defense. What is that defense that D has? Well, let's go back up to the fact pattern. D has the affirmative defense of contributory negligence, and D also denied that D was drunk, right? But of course, we all know there's a difference between a denial, number 1, and an affirmative defense, number 2. And in fact, the rule refers not to witnesses who you can use to support your denials, but rather your defenses. So the question really here becomes, when we say support your defenses, does that mean, number 1, just affirmative defenses, or 2, anything that helps D? And the better answer appears to be number 2, okay? Not just affirmative defenses, but also anything that supports the defendant's denials of the plaintiff's allegation, right? And I'll admit, you can make a pretty good textual argument that supports defenses is covering defendant's affirmative defenses, but not defendant's denials of the plaintiff's allegations, right? Nonetheless, the year 2000 advisory committee comments, plus other commentators, provide some decent authority for suggesting that supporting defenses includes not just affirmative defenses, but also denials of an opposing party's factual allegations. So probably the better answer here is that defendant must disclose witness 3. Okay, and indeed, just as a practical matter, why would defendant not want to disclose witness number 3? This is going to help the defendant's case and maybe help to convince the plaintiff ought to settle on terms that are more favorable to the defendant. All right, see, well, what does that leave us? What must be disclosed pre-trial? When must it be disclosed? Rule 26A3. Now, I'm going to really not going to go into disclosure of expert testimony here at all. We'll leave that for a course in complex litigation. But that's a type of disclosure that has to be made. And then pretrial disclosure, of course, is shortly before the trials. Okay, unless the court says otherwise, it's going to be at least 30 days before the trial, and then a little bit after that, within 14 days after they're made, unless the court says otherwise. Objections may be made by the opposing party. What has to be disclosed? Witnesses, names, address, phone numbers. Okay. And note here that it doesn't carve out impeachment witnesses or anything like that, but rather it's witnesses that the party expects to present and that it might call. Okay. Witnesses who the party is going to present by deposition, and if not stenographically, then a transcript, right? And then finally, ID of each document or exhibit and so on that's going to be presented. Okay. So that's a little bit more straightforward. The difficult one for right now is going to be the initial disclosures, and we talked about that in some pretty significant detail. I think that leaves just one more thing, which is the scope of the duty to supplement disclosures and discovery requests. And here, now we're looking at Rule 26E, okay? And let's start off by looking at the rule, and then we'll go ahead and do the hypos, okay? So the rule says a party who's made a 26A disclosure, and remember, that's 26A, so that's going to include the initial disclosures, the expert disclosures, and pretrial disclosures. So it covers disclosures. It also includes those who respond to interrogatories, requests for production, or requests for admission. They have to supplement that disclosure or discovery response, okay, in a timely manner if the party learns that in some material respect that disclosure or response is incomplete or incorrect, okay, in a material respect. Not in a minor respect, but in a material here, in an important respect. And if the additional or corrective information has not otherwise been made known to the other parties during discovery or in writing, or as ordered by the court. And there's also information on supplementation of expert witness disclosure. I'm not going to get into that. All right, well, let me illustrate this through a couple hypotheticals. But let's start off with the basic idea that, there's been disclosures or discovery, and later on you find out that something turned out to be wrong or it's incomplete. And not only is it wrong or incomplete, but it's wrong or incomplete in an important, in other words, a material way. Well, when do you have to fess up and give the additional information? All right. Number one, P, plaintiff asks D in an interrogatory. Okay, we'll talk about interrogatories in a bit. That's Rule 33. That's basically a written Q and a written Q and answer. Whether the defendant has ever received any complaints regarding an alleged brake defect. Defendant responds in good faith saying no. Okay, I say good faith so that we're not thinking the defendant's lying. Rather, it just turns out the defendant is wrong, right? So later on, D finds a document showing a complaint from a customer regarding the brakes. Must D fess up and supplement the interrogatory? The answer here is going to be yes. Why? Because, go back down here to the rule. All right. Is this a disclosure? No, it's discovery. Has there been an interrogatory, production, or request for admission? Yeah, there's been an answer to an interrogatory, not for production, not for admission. Okay, so there's been an interrogatory response. And look at the rule. The party did in fact learn that the answer was in some material respect incorrect, and that information had not otherwise been known to the other parties. So there's a duty to supplement. The party is going to have to contact the other party and clarify the record. Question number 2 builds on question number 1. What if the defendant does not supplement the interrogatory but discusses the customer complaint during a Rule 30 B6 deposition? We'll talk about depositions in the next video. A 30 B6 deposition is when you're deposing a corporation and you say, hey, I want the corporation to be deposed, or I want, say, the head computer person at the corporation to be deposed. And you don't name the person who's going to be deposed, but rather you just name the type of person, the corporation you want to talk to, and then the corporation designates somebody to be deposed on behalf of the corporation. So in other words, 30B6 deposition was the corporation is being deposed on some topic, right? All right, so in question number 2, still we have the interrogatory from question number 1 that turns out to be wrong, right? But that information was fixed during a deposition, okay? Is there a duty to supplement? And you might think the answer is yes, because the interrogatory was wrong and nobody ever pointed out the error in the interrogatory. But the answer here is actually going to be no. Okay, why? Because the information, in fact, was corrected. The correct information was given. We look again at the rule, right? We had an interrogatory answer. Okay. In some material respect, the information was, in fact, incomplete. But this last clause is an exception. We don't have to, this is the exception here. There's no need to supplement if the corrective information was known to the other parties during the discovery process. Well, that was the 30 B6 corporate deposition. Okay, so there's no need under these circumstances to supplement. All right, question number 3. Suppose during a deposition, okay, so now it's a new fact pattern. Suppose during a deposition, defendant was asked how many complaints it received. Defendant says in good faith 1. Later, defendant realizes the answer should have been 20, must desupplement the deposition. I'm sure you think the answer should be yes, because the deposition was wrong. And in fact, it wasn't just a little bit wrong, it was a whole lot wrong. Sadly, however, the answer is no. No, the answer is no, and I'm going to put a big but there, all right? The answer is no. Why? Well, look at Rule 26E. Party makes a disclosure. Well, deposition is not a disclosure. It's a type of discovery. Or has responded to an interrogatory. Nope, it was a deposition. Request for production? No, it was a deposition. Or request for admission? No, it was a deposition. Must supplement. Guess what? There's no duty to supplement a normal FW, fact witness deposition. Most depositions are of normal fact witnesses. A fact witness is somebody who's testifying based on their own knowledge, right? What they've seen, what they know. There's a second kind of witness, which is called an expert witness. And in fact, the duty to supplement for expert witness includes not just the expert's report, but also the expert's deposition. So there is a deposition supplementation requirement for expert witnesses, but not for a normal fact witness. Okay. In other words, under Rule 26E1, depositions are not listed, and therefore there's no duty to supplement the deposition. It's only when the deposition is an expert witness would there be a duty to supplement. Well, so the correct answer is no, but I said no, but, and here's the but. Now imagine your client testifies at a deposition that the answer was 1 complaint, and later on you find out that there's 20. Well, do you have to supplement? The answer is no. Should you supplement anyway? I'm hoping your response is absolutely you should. Think about how this is going to come out. First of all, if there's 20 rather than 1 complaints, then probably that information is going to come out somewhere, somehow anyway. It might be another witness. It might be documents or electronically stored information, right? Or it might even be research. And here I'm talking about informal fact finding by the opposing party. The truth will typically out. And if the number was not 1, but rather 20, then there's a pretty good chance that either through discovery, through investigation, it's going to come out that your witness at the deposition was wrong. Now, hopefully they weren't lying. Hopefully they were just mistaken. But you really want to clarify this because A, the information is going to come out anyway, and B, if that information comes out and you haven't been the one to correct the record, okay, then what's going to happen during trial is people are going to use your witness's wrong statement to try to paint that witness as a liar. In other words, to impeach that witness. All right? So even if there's no duty to supplement, oftentimes the smarter move is going to be to just come out with the information. You be the one to be honest. You to be the one that looks good to the other side. You to be the one to make sure that your witness or client is not painted as a liar later on when they've made a hopefully honest mistake. All right, so I think that's it. We've actually already answered number 4. We haven't, because I made reference to expert depositions, and yes, they do need to be supplemented if the error is a material omission or material misstatement. So the answer would be yes. All right, so I guess that's it for this video. We've done all this stuff. We've covered quite a lot of material, and I hope you once again have found this video to be helpful and moderately entertaining. And I've enjoyed doing these videos for you, and we'll have a few more coming your way in the next couple of days. So be well. Talk to you soon. Nathenson out.